Good afternoon, Judge Weiner.
Good afternoon, Justice Meyer.
How are you?
I'm fine, thank you.
All right. The JSC interviewed you for a position at the SA not so long ago.
Yes.
Just remind me, when was that?
April 2021.
It was just last year. Well, as I recall, at that interview, it was established beyond doubt that you're an experienced, hardworking, and efficient judge who is committed to transformation and mentoring and training of women and young and upcoming lawyers, which in fact is why the SA has kept inviting you back to act whenever there's been an emergency, and you have so many acting stints under your belt.
Yes.
But despite all that, you did not make the cut. And I think you'll recall well better than me that your age was a matter of concern for a number of the commissioners. I'm not saying that's why you were not recommended for appointment, but it was an issue. So I'm not going to waste your time. We have, we know who you are. We have your record of the recent proceedings. I just want you to tell us in your own words why the JSC. I mean, it's a year later now. You're a year older. Why should the JSC change its mind and recommend you?
Yes. Justice Meyer, as you know, in the past 3 or 4 years, the SCA has lost 11 of their senior judges, either through retirement or elevation. All had served more than 15 years. With my 33 years of experience at the bar, 15 years as a silk, and coming from the busiest division in the country, I do believe that I have the knowledge and experience which could be of benefit to the Supreme Court of Appeal at the moment with the experience that has been lost. I have been acting since when I took silk in 1995. I acted in the Gauteng, that was then the Transvaal Provincial Division, and then the Gauteng Division, for a few weeks every year or every couple of years. So I gained a lot of experience on the bench. And as J.P. Malambo pointed out last time, with the judiciary in particular, the more experience a judge has, the more resourceful and productive they can be. If I look at the Gauteng local division, for instance, the more experienced judges contribute enormously. They do a lot of the training and lecturing. They take on many case managements, commercial court matters, special motions, and they feel comfortable, as I did, dealing with virtually every sort of matter that may come before the courts. As will appear from some of the comments from the law bodies, my practice as a silk, as well as being a judge in Gauteng, I dealt with virtually every possible type of case that could come before those courts and before the SCA. You also feel more comfortable as an experienced judge to discuss things with colleagues that you might feel uncomfortable doing when you're a younger, less experienced judge. I have absolutely no qualms in going to my senior colleagues, and even some junior colleagues, I must say, who to discuss matters that I have, if I have some issue that might be worrying me. And I think as a younger judge, one feels that you might be regarded as stupid or inexperienced. So it's something that comes with age. And, you know, as one gets more experience, it makes things a lot easier, so that every day is not so quite challenging as the day before. With that experience and the knowledge acquired along the way, one hopes that fewer errors occur, and they're all part of the learning process that increases one's feelings of self-confidence and security. As you know, I first acted in the Supreme Court of Appeal in 2019. And unfortunately, there were no vacancies in 2019. And then there was 2020 was COVID. And in October 2021 and March 2022, there were no vacancies either. So I have sat in the SCA as an acting judge during all those periods when, if there had been vacancies, perhaps I would have been able to fill one of them. So although it is now sometime a year and a half down the line, and I then had approximately 6 years, and I now have 3.5 years, I do believe that with my experience that I've had, as I've set out in my practice as an acting judge, as a judge, and now as acting in the SCA for the past 4 years, that I can bring that wisdom and experience to be used to the benefit of the court. I have helped and mentored younger colleagues at the SCA and of course at the local, at the Gauteng division, and I'm willing to do so and continue to do so. And I feel that I can still add a lot to the SCA, even if it is for a relatively short period of time. And I must say it's not unprecedented. In the last interviews, 5 men who are either the same age as me or the same period of time left were appointed. And as was mentioned earlier by, I'm not somebody, I think it was Commissioner Malema, that our Chief Justice only has 3 years to go. So it's something that I believe I can add to the court. I can use my wisdom and experience, and hopefully I won't be taking up somebody else's position for a long period of time, which would allow the court to appoint someone else. I also think that transformation insofar as gender is concerned has been very slow in the legal profession, more so in the profession than the judiciary. But if one looks at the Supreme Court of Appeal, Judge Leonora van den Heever was appointed in 1991. After that was Judge Lewis, Van Heerden, Snyders, and McClunter. But since 1991, there have been 18 women judges in the Supreme Court of Appeal, out of very, very many more men. It does remind one of what Ruth Bader Ginsburg said when she was asked, when will there be enough women on the Supreme Court in America? And she said, when there are 9. And they looked shocked, and she said, why? You weren't shocked when there were 9 men. So I think that transformation in the judiciary has advanced well, but as far as gender goes, it is still lacking. And as I will speak of more if I'm given the opportunity, the problem is that the transformation in the profession is slow. And if one's going to get gender and race parity on the judiciary, one has to look at the profession, because that's where judges are drawn from. And those sorts of transformation issues deserve to be dealt with in a very serious way. So I believe that I can contribute in that way. I've always been a mentor since my first years at the bar. I've assisted in aspirant judges training, in the acting judges training, in diversity training, and I believe that the intergenerational collaboration on a bench such as the Supreme Court of Appeal needs the diversity that comes from age, gender, and race, and that way the judiciary can actually be strengthened. So that is what I believe. I think that I can add to the experience needed at the Supreme Court of Appeal. There are other ways which I believe I've been quite, if I can put it, influential in seeking to develop social cohesion at the Supreme Court. Well, I don't think many people realize that most judges that are not based in Bloemfontein permanently, all come there and rent out small Airbnbs or apartments and are basically alone. And what I've tried to do is arrange a dinner, and I have invited you, Acting AP, once a week when judges are not sitting or when the presiders are not sitting. And we've got together something like 10 and 12 judges every week from right across the spectrum. And it's been a very enjoyable and social cohesive process, which I think has really added to the collegiality that is present at the SCA, and which I believe, Justice Meyer, you had an important role in developing that cohesion that exists at that bench at the moment. Sorry, I can't hear you.
Mic is not on. Do you have any health issues?
No. Not that, as you're all aware, I did have cancer in 2010, but I've been in remission since then. I've had one or two problems with my eyes this term, but it's due to my prescription having changed, and I've had to had new glasses. But I think that is for most people, if I look around the tables, that everybody at some point needs some sort of aid with spectacles.
Yes. Well, I can vouch for the fact that you're one of the fittest and healthiest, people I know in our age range, that is. All right, I'll hand over to my colleagues to put questions to you if they have any. Commissioner Nyambi, you may start asking your questions.
Thanks. Thanks, DCJ. Afternoon, Judge.
Good afternoon, Commissioner.
I've read your interesting article that you wrote some years back about women at the bar. Where have the young girls gone? And if you look at the judiciary today, part of what we're grappling with is the reality that you spoke about, how they are excelling academically, but in all the divisions that we have in the country now, they are led by males. If you look back then what you wrote and the current challenges facing the country, what might be the challenge that is making the situation that we have that is not right?
You mean insofar as transformation of the profession and the bench is concerned?
Definitely.
Yes. There have been improvements, I must say. I've looked, when I was at the bar and when I became a senior counsel, I was the only female doing commercial law at the time, or contract law, not matrimonial law. But that has changed, especially in the high courts. I mean, there are several female silks now. There are several very competent young females doing commercial law, and one is proud to see that that has happened and that it continues to happen, and it's not that unusual to see females in these complex matters in the High Court. However, surprisingly enough, it doesn't filter through to the Supreme Court of Appeal. In the time that I've been there, in my matters, I've only had 3 female counsel who've appeared. They've been juniors, but those that have speaking parts, as they're so called, are very few and far between. I think that there are more females in the Constitutional Court appearing in the Constitutional Court and in commissions of inquiry and various other tribunals. But it seems to me that there's just so much that we as judges or even advocates at the bar can do, because it's a mindset that the profession has. It's a mindset that attorneys have. It's a mindset, unfortunately, that I think the state attorney has, because the briefing patterns, the biggest briefer is the state attorney. They have the most briefs, and they do not brief women as much as they brief men. And it is very difficult to understand why this is happening. And it really has to be a complete change of mindset. We did at the bar try various things, such as bringing in a third junior, which was paid for by the Silk, which I think has worked quite well. I did that throughout my career as a Silk. I would bring in young black or female juniors, and that way you get transfer of skills, you can recommend them to attorneys, etc. So it can happen from within the profession, as I think it has been happening. There are some excellent female Silks at the moment who are showing that it is certainly possible for them to advance. And as I say, it just needs to now lift up to where it becomes a matter of course as opposed to a matter of exception. But I believe there's still a lot of work to be done in that regard.
My last question. We interviewed you in April last year, as DCJ has indicated. Any particular thing that stand out that we have to consider this time around? What has happened in your life since then and now?
Well, since then, I've continued to act in the Supreme Court of Appeal. So I have, I think, shown my worth to Justice Meyer and Acting President Petse. And I have developed sort of more knowledge of the ways in which the SCA works. I've got a lot more experience. I have been called in to assist younger judges in some of the judgments that they're writing. And I've also been involved since then in a lot of judicial training, as I've said, of aspirant judges, of judges in the high courts. And I think that that has added to my experience and my ability to offer what I have to the Supreme Court of Appeal.
Thank you, Judge Weiner. Thank you, DCJ.
Oh, she's missing.
Thank you, Commissioner Nyambi, but I'm not the DCJ, unfortunately. Commissioner Matolo Lepo.
Thank you, Acting Judge President. Good afternoon, Judge Weiner.
Good afternoon,
I
Commissioner.
just wanted to, Commissioner Nyambi took everything that I wanted to ask. I think maybe you are sitting next to me. But now I want to applaud you for the role that you are playing with training women in law. And to me, you know, you are one of the people, when we talk transformation, we can see it. And I hope you'll take it along wherever you are going, because you bring so much hope to these young women attorneys, especially attorneys. They really get excited when you speak about Judge Weiner, because they can actually give you a call and you respond. But just to follow up on what Commissioner Nyambi is saying, I think we've been speaking about, especially your article about where are the young women going. You know, some of us get very despondent, you know, because we've been preaching this women empowerment and it doesn't seem to move, you know. And we're trying, the legal sector code is not moving. So what other things can we do? I mean, it's just maybe a comment from you.
I think that there needs to be more effort made on individuals' parts, because insofar as institutions, big firms, and the state is concerned, sometimes the process is simply too complicated for them. But if one looks at it individually, and I know there are many, many men at the bar as well as women, and in the attorney's profession, where you are seeing women rising to higher positions in attorneys' firms, but there are many men and women at the bar who not only get involved in advocacy training and training of attorneys and helping development of skills, but development of skills only goes so far. One needs then to see some sort of result from this development of skills. And I think the way in which it's being done, and it just needs to be done more, is what I keep saying, is that young women, young blacks, and even at a higher level, need to be brought into matters. They need to be given a chance. That's all they're asking for. Because once they're given a chance and they prove themselves, they can go off and people will then want to brief them and want to bring them into matters. So it's really simply a thing of, please, will the senior people in the profession give people a chance? You know, it's this, there's this wonderful author called Peggy McIntosh who writes about the invisible knapsack of white and male privilege. And what she says is that white men are considered competent until the opposite is proved, whereas blacks and females are considered incompetent until the opposite is proved. And I think that is the biggest problem, that it is perceptions. It's immediately, if you're black or female, you're possibly unable to do the job. Whereas if you're a white male, it's simply taken for granted that you can. And that is where the whole process goes wrong. Just if the profession, if the state can give people a chance. I've tried even on the bench when I see, when I'm doing some training and I see potential in young blacks or women, or young black women, I immediately contact my colleagues at the bar and attorneys that I know that used to brief me. And I say, these people are excellent. Please bring them into your matters. And they do. So I think from an individual's point of view, it's one thing that people can do strong, in a more strong fashion and do that consistently.
Thank you very much.
Thank you, Commissioner Matolo. Commissioner Steinberg.
Thank you, Acting President. Just a comment, Judge Weiner.
Yes.
I also just want to acknowledge the extraordinary contribution that you've made to women. It's sad, but not all women actually support women. In a profession where we compete with each other.
Yes.
And you truly have been inspirational to generations of women and have not only trained, but have opened doors, made opportunities, encouraged, and it's really a heartfelt thank you for that. And I also noted that this business with age seems to apply more to women than to men, and I am wondering why that's the case. Thank you.
Yes, that is a good question. Yes, thank you, Commissioner Steinberg.
Are you done, Commissioner Steinberg? Thank you. Professor Maru Bukhwai.
Thank you very much, AP. Good afternoon, Judge.
Good afternoon, Professor.
I've heard the benefit of reading some of your judgments, and I was quite intrigued on those particular that you dealt with business rescue and your approach. But I'm not going to deal with those. There is one judgment that you wrote when you were still an acting judge. I hope you still remember it. And that judgment, I think, in the area of law which it was on, in my view, it is a seminal judgment in that area, and better than all the judgments that came even before, after it. F versus F, I'm not sure if you remember, it dealt with child relocation disputes.
Yes, Justice Meyer was in fact the judge who upheld my judgment in the SCA.
In fact, before it went there are two judges who agreed with you at the And of course, Samuel J disagreed with you and took a very feminist approach to it. And I will tell you why I'm raising this issue with you. In that judgment, you raised a serious question, which none of the judgments, including the judgment by Justice Meyer at the time, and Jackson versus Jackson as well, they did not grapple with that issue because they took a constitutional element and the rights of women and all those things. But you asked a very important question in relation to how do we look at the custodial parent who wants to actually relocate with the child. And the fact that she particularly wants to relocate, does that necessarily mean that that is in the best interest of the child? And I'm not sure if other judges, including the Supreme Court of Appeal, has actually grappled with that issue. By not looking at it from a feminist point of view, but just looking at the child and the parents who are looking. I'm not sure, do you have any view in relation to that?
Yes, I must be quite honest, and I appreciate your stating that it was a seminal judgment. I did consider it to be so as well, because there was, at that stage, I think it was 1990, it's here somewhere, it was simply assumed that women should get custody. And if they were relocating, it was a matter of course that the children would go with the mother. But this was one of those cases where the father had an equal input into the child's life. And I thought that one can't simply look at it as, well, the mother must get custody of the child because she's the mother. It was a very difficult decision, I must admit, because these relocation cases are tragic most of the time because there's one parent that gets left behind. But if I looked only at the best interests of the child, which was the test that I applied, the child did not want to be removed from her father. The mother had the option of staying here. It was simply more convenient for her to go back to the United Kingdom, where she said she might have more support, but she had no concrete reason to go. And I just believed that it was in the best interests of the child that it's taken into account what her father offers to her as well, and that whereas the mother had the option to choose between the two, she was not choosing the one option for very serious reasons. It was simply a preference on her part. And I believe that it was in the child's best interest not to allow the child to go with her.
Well, I think that is their best case in child relocation disputes. And it played a very central role in my thesis as well, and I want to say thank you to that.
Thank you, Professor.
Thank you, Professor Marumohai. Minister Lamula.
No, I'm covered.
Thank you, Minister. Commissioner Dodovu.
I'm also covered by Honorable Nyambi, Chair of the session.
Thank you, Commissioner Dodovu. Commissioner Magwanishe.
Just one question. Thank you very much, Acting President. Good afternoon, Judge.
Good afternoon, Commissioner.
It is just a follow-up from Commissioner Steinberg. In your experience as a judge and as an advocate, how has the system made women to be agents of patriarchy?
Sorry, just say that again. How's the
How has the system made women to be agents of patriarchy within the legal profession?
It has certainly contributed to that. In a society such as ours, where patriarchy is so deeply embedded into our society, one has to realize the value of the participation and contribution that women can make to the system. And it is a barrier that has been up for much too long. The glass ceiling needs to be shattered. It has started to be shattered, but it needs to be completely destroyed. And when I gave you the example of men being looked at in the sense of they're competent just like that, whereas women have to prove themselves, that is proof of patriarchy. That is the assumption that people have. And to break that glass ceiling takes a lot of courage. I mean, I must have threatened to leave the bar at least once a week in my earlier years because it was so difficult. It was in the 1970s. I'm now really giving away my age. It was in the 1970s where it was simply unheard of. There were 6 women at the bar of, I think the bar was about 500 at that point. They were all doing matrimonial work, and I do not denigrate that in any way, but I simply didn't want to be put into this box of that is what you are going to do because we say so. So I wanted to escape that box, and I managed to do so. And I do believe, as I thank Commissioner Steinberg for saying, that I did have some influence on the progression of women at the bar and assisting them to break out of the cages into which they were put.
Thank you, President. Thank you, Judge.
Thank you, Commissioner Makwanisha. Commissioners Barnett and Bredenbach, any questions for the candidate?
What was it?
Yes, you may proceed, Commissioner Barnett.
Thank you, Judge Weiner. Good day. I noticed that you were on one of the Bobroff judgments.
Sorry, you see.
Around certain interpretation and transgressions of the Contingency Fees Act.
Yes.
And I know currently our minister is grappling with part of this as part of the South African Law Reform Commission's report that's lying on his table. Question is this, is how do you see the future of contingency fees in South Africa? What can work and what should happen in that regard?
I think that a contingency fee agreement in itself, there's nothing wrong with it, but I think it is being used by certain practitioners, or should I say it's being abused by certain practitioners, because at the end of the case, they simply say, well, this is what they've done. There's no checks and balances in that regard. And it has to be, I think, stringently regulated in the sense that if someone is going to enter into a contingency agreement, it needs more than simply this layman to sign a document saying they understand. There has to be something more that needs to be further regulated so that litigants know what they're getting themselves into. It can be checks and balances along the way as to each consultation or each appearance, because in that case, they were simply adding a 15,000 Rand fee, general fee to every case, every matter that they had, as I'm not sure quite how they described it, but every case had a 15,000 Rand charge to the client. So it needs to be regulated, it needs to be very well supervised, and judicial scrutiny is essential. And I think that was part of the Maswanganyi case that was decided by the SCA it was actually my first judgment in the Supreme Court of Appeal, where judicial scrutiny was deemed to be essential, especially when public funds are being dispersed. So I think that there needs to be more regulation and stricter observance of the rules, and perhaps this is where the LPC may come in, although I know they're very overburdened. But these sorts of things need to be dealt with in a very stringent fashion.
Thank you, Judge. Thank you, Acting President.
Thank you, Commissioner Barnett. Commissioner Bredenbach.
Thank you, Acting President. I don't have a question, just a statement, and forgive me for not switching on my camera. We're having load shedding, so I've got serious connectivity issues at the moment. Good afternoon, Judge Weiner.
Good afternoon, Commissioner Breitenbach.
I just have a sort of a statement. I just want to agree with Commissioner Nyambi that age is not the determining factor, and that older people do have things to offer. And just to mention that your comments about the glass ceiling, certainly yourself and your colleagues at the bar at that time, yourself, and others, inspired a lot of women, myself included, to get through that glass ceiling. So we owe you a great debt. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Breitenbach. Judge Weiner, I see that your first acting stint at the SCA was in April 2019.
Yes.
And since then, you have acted for 9 terms in that court.
Correct.
And how many judgments did you write during that period?
I've got the note here. I wrote 15 judgments. And I think that 6 have been reported.
Thank you. I had the benefit of reading the record of your previous interview, and I couldn't pick up anything adverse, unless I missed out something.
I hope not.
And what would your response be to those colleagues who believe that, or who have some reservations about your judgment writing skills, especially writing for the SCA?
Well, I started off with a baptism of fire. My first judgment was written for Justice Meyer and Justice Wallace. And he certainly taught me a few lessons in my very first judgment. When I looked at it, though, it appeared that it was mainly structural, not so much the content, but the structure that he felt needed to be changed. There were one other judgment that I had some problems with, I admit, and I went to discuss it with both Justice Ponnen and Justice Wallace. And we discussed it, and I worked it up with Justice Wallace. That was the, sorry, just let me get that. Umgeni water tariff matter, which Justice Wallace did change my original judgment quite substantially, which I accepted his changes, and in fact I suggested to him that the judgment go out in both our names. In fact, I first suggested to both Justice Ponnen and Justice Wallace that it goes out in Justice Wallace's name, but they both said that I had put in a lot of work into the judgment and they thought that it should go out in both our names. It was then overturned by the Constitutional Court. And that is one of the judgments that isn't here insofar as judgments that have been successful on appeal. So there were 4 and that were mentioned, and this is the other one that came out later. And so, yes, there are 5 judgments in which my judgment has been overturned. So insofar as judgment writing is concerned, I think that I have produced good judgments. Most of them have been, other than those 2, the judgments have been well received with certain structural changes. It's a stylistic thing, and a lot of some judges like to put up front what the case is about, and they're the legislation, and others like to do it differently. So it is it's quite difficult to follow sometimes because you're not quite sure which way the presider will prefer. But I believe that I have written useful and constructive and good judgments in most of the cases.
From that experience you had with those two judgments, can you now reassure the Commission that you can produce proper and well-written, well-reasoned judgments for the SCA?
Well, I believe so. As I say, I've written 15 judgments, and those were the only two in which I received quite a lot of assistance, which I took on. They were both very senior judges, and I accepted what their advice and their comments that they'd made, and I hope that I learned from that and have gone on to write much better judgments since my first two.
Thank you.
Follow-up.
Before we excuse you, is there any other thing that you wish
Sorry,
to...
AP, can I follow up from the question that the last question that you wrote?
Oh, I beg your pardon, Professor, you may.
Yes, I said, can I please, oh, I may. All right. Thank you very much, Judge. You know, the thing is, I'm getting some sense of unease with the way things are happening at the Supreme Court of Appeal, and perhaps one day we'll get a full sense of what is going on there. My discomfort is this. Judges are appointed to different divisions of the High Court, and they write many judgments. Well, we know writing, it's a different sport, right? And all of us have views on how other people write, and we can criticize each other, and that is fine, academically and in practice. There seems to be a way in which one writes for the Supreme Court of Appeal. And if one doesn't write in accordance with how one should write for the Supreme Court of Appeal, then the judgment might be thought, the draft might be thought of not being proper, not being adequate. I have some unease with that. And the question I want to pose to you is this. When judges comment on your draft, genuinely, when you receive the comments, do you genuinely believe that they improve and help you, or is it a matter of conforming to what is going on in that court? Because they are seniors and they are assisting you. I just want to understand your true and honest feeling in the assistance that you got in relation to the initial judgment because I have a serious unease with what I'm hearing is happening at the Supreme Court of Appeal. Thank you.
Yes, I understand your sense of unease, and I think not so much today, but a few years ago, like when I first started acting, there were certain judges who have certain ways that they thought judgments should be written. It was my very first judgment in the SCA, so I was a little unsure because there is a different writing style in the SCA. One doesn't go through all the facts and etc. One tries to keep it concise and on the particular point. It was an interesting judgment because, in fact, I thought that I was going to dissent from everybody in that judgment. That was the Masangani case about the RAF and agreements. Because when we first started discussing it, they all said, well, you know, it's an agreement and the parties concluded it and etc. And I said, one needs to understand what goes on in the high courts, such as my division, where we get hundreds of RAF cases. And there is a scam going on. People are being paid money. You get an agreement and it says 2 million rand and the person sprained their ankle. And I said, we have to look at these judgments, at these agreements, because this cannot carry on. No wonder the RAF is bankrupt. So I managed to convince, well, I think Justice Meyer was already on that side, and Judge Wallace also came over. There were 2 dissenting judges in that matter. But I did think that this is my first case. These are very senior judges. I can learn from them. In the end, the judgment was structurally slightly different to what I had prepared, but I thought that my judgment was adequate, but I took the advice and I took the comments simply because...
No, thank you. I think you have answered me.
Yes, thank you.
Thank you, AP.
Thank you, Professor Moromokai. Judge Weiner, you would of course know that when colleagues provide you with their suggestions, it is up to the scribe
Yes.
to decide whether you want to adopt or reject them.
Yes, absolutely.
And indeed, some colleagues would even say so in so many words, here are my suggestions, please adopt or reject as you
Yes.
wish.
That does happen, and I have done that ever since I have been writing judgments in the SCA. As I say, I did, when there are valid comments and contributions, I will adopt them, but I'm also independent enough, I think, to believe that what I think is a good judgment is in fact so.
Thank you. Is there any other thing that you would want to draw to the attention of the Commission before we release you?
Well, there's just some stats, if I can say, that since I've been a judge, I've written, as far as I can see from the records, 224 judgments. There are over 30 that I could find only recently. For some reason, the earlier judgments didn't come up in my searches, but there are 30 that have been reported. Since 2018, I've written 70 judgments, and 13 have been reported. So I believe that I have the experience from my years. As I've stated, I don't want to repeat myself, and that experience can be of a benefit to the SCA for the time that I have left to serve and which time I would like to serve on the SCA. Thank you.
Thank you, Judge Weiner. Just bear with me for a moment. Judge Weiner.
Yes.
Judge President Mlambo.
Oh, sorry, JP.
There's a short question for you.
Yes.
Good afternoon, Judge Weiner.
Yes.
This is basically a follow-up to the transformation questions that were raised with you earlier. I think I'm just asking for your views, if you have any, about how we can deal with it. My experience since I became JP of Gauteng, even with the labor courts, is when it comes to senior members of the profession, they do not easily avail themselves for acting appointments.
Yes.
Both black and white. And the trend is, it's the recently acquired silks who usually avail themselves even for permanent appointment.
Yes.
It is a hurdle, it is a challenge to us as heads of courts, because we need to address the challenge that has been mentioned here of lack of leadership from the female ranks in the judiciary.
Yes.
Do you have any comments to what I'm saying? Because we really need help.
I think that the seniors at the bar, and I'm not sure of the attorney's profession because I wasn't a member, have abdicated their responsibility to both the judiciary and to the bar. If you look at the bar councils, they consist of very junior members. The silks are junior silks. None of the senior people avail themselves of those positions. It is a great responsibility, I concede, but it is something that is so essential for the administration of justice, for the rule of law, that those people make themselves available. And I'm not sure if this is what you do, but I would, if I can just give a little piece of unasked for advice, I would ask the senior silks to give you a time, throughout any time in the year, where they are prepared to serve for even 2 weeks, because having them on the bench adds gravitas to the bench. It will make people want to appear more frequently. We know that people are going to arbitration, and I think that if there were senior silks who don't avail themselves for a permanent position, but if they make themselves available to act for a certain period of time, I think that would assist. And as I say, I really do believe that the senior silks have abdicated their responsibilities.
Thank you, JP. Judge Weiner, we have now come to the end of your interview.
Thank you.
And you are excused at this stage. Thank you.
Thank you.